稍等一下，杨子那边还有一点事情。杨子，我们仲裁员都准备好了，你那边可以的话，你可以放他们进来，然后现在倒数15秒。好的，对，倒数15秒，那个直播信号就放出去。
好嘞，那我现在开始。
欧锦涛啊，对，欧锦涛 ，OK， 锦涛，谢谢你。
现在就是我们还有大概10秒钟开始直播了，请各位队员改一下自己的名字。差不多，杨子，你可以按那个 Start Webinar 呢，我开始说了。
Clayman，你们有2个 Cedric。
对，请他们改一下名字。2个人如果在一起的话，请把2个人的名字都写在上面。
哎，锦涛，我这个想要一个虚拟背景，怎么掌握？怎么出不来呢？
你能看到左下角有一个
没关系的，白老师，我们不硬性要求要虚拟背景的。
OK fine，OK， 我这个背景呢有点黑，主要是没关系，那来不及就算了。
OK。
因为我这个现在这个虚拟背景的选项是 none。
改好了，杨子。那我们开始。
OK。
10号队是2个人坐一起的，没问题。
好，他们都是在一起的是吗？
对。
OK， 在一起会好一些。
好的。
不好意思。
Good afternoon, everyone from Hong Kong. Welcome to the final of the second CETA Cup for Investment Arbitration Moot Court. I'm Fang Han Chen, MC of this final. The second CETA Cup is a China national round of the 30th edition of the Frankfurt Investment Arbitration Moot Court. And before we start the thrilling competition, allow me to introduce the 3 arbitrators sitting as the tribunal for this final. The first arbitrator is Mr. Zhang Xing. Mr. Zhang is a partner at Global Law Office, and he provides legal services for Chinese and international banks and investors in relation to the banking and finance, MA, FDI, and overseas investment. Yang Zi, would you please give spotlight to Mr. Zhang? Thank you. And Mr. Zhang has extensive experience with a coverage of financing, energy, power, real estate, and natural resources sectors. He has represented a number of industrial investors to invest in Chinese petrochemical, renewable energy, power, telecommunication, and other traditional manufacturing sectors by way of greenfield investment or merger and acquisitions. He also provides legal supports to Chinese SOEs, banks, and investment funds for their overseas investment and financing projects under the Going Abroad efforts. Welcome, Mr. Zhang. And our next arbitrator is Ms. Olga Botenko. Ms. Botenko is a partner at Fonda Partners in Hong Kong. She specializes in investment arbitration, and she has acted as legal counsel in investor-state disputes under the auspices of the Permanent Court of Arbitration and as tribunal secretary in dozens of commercial disputes, both ad hoc and institutional, in a wide range of industrial, including oil and gas, construction, telecommunication, and pharmaceuticals. She is an adjunct lecturer at the University of Hong Kong. She chairs the ICC Hong Kong Commercial Law and Practice Committee. She's also listed as arbitrator on the CTAC, HKIAC, AIAC, and SIAC panels of arbitrators. Ms. Botenko, welcome. And the presiding arbitrator, Mr. Bai Xianyue. Mr. Bai is a managing partner of Grandall Law Firm Tianjin office. Mr. Bai has been practicing as a Chinese lawyer for 20 years and has been involved in various litigation and arbitration cases, both as counsel and in the capacity of arbitrator. He frequently speaks in international conferences on Chinese law across the world, and Mr. Bai is listed as arbitrator on the CTAC, HKIAC, CAS, SHIAC, SCIA, and AIAC panel of arbitrators. Mr. Bai is also a special mediator of Singapore International Mediation Center. Welcome, Mr. Bai.
Thank you. My pleasure.
Thank you, arbitrators, for participating in the second CETA Cup. The two teams sitting at this final is team number 30, the claimant, and team number 10, the respondent. I'm now passing the floor to the moot court secretary for this final, my colleague, Mr. Jingtao Oh. Jingtao, the floor is yours now.
Thank you, Fang Han. Well, good afternoon, teams, members of the tribunal. Thank you for attending this hearing. I will be the MUCA secretary for this hearing. So before we start, there are some parameters that you may need to observe. They are different from the general round. The first one is, in the final, there will be 45 minutes for each team, which means the 2-hour list of the same team will share the 45 minutes. Second, the teams should negotiate or confer on who should be counting the time. And the tribunal can decide on this if there is any disagreement. And members of the tribunal, if you don't have further questions, then the proceeding may start. Thank you.
Thank you. Thank you, Jintao. According to the rules of the organizers for this investment moot, the teams are supposed to discuss among themselves and reach an agreement on what are the 3 issues you want to cover in this session. Counsel for the claimant and counsels for the respondent. Have you been in a discussion and have you reached an agreement on this? Thank you.
Yes, Mr. President, we have had a negotiation beforehand and we have reached an agreement on the issues.
Okay.
And
what are they, please?
The issues that we will be discussing now are issues 3, 6, and 7.
3, 6, and 7. Have you among yourselves happened to discuss the sequence in terms of your submission for each of the 3 issues?
Yes, Mr. President, we have agreed that for issue 3, claimant will go first, and then respondent will do issue 3. And then for issues 6 and 7, respondent will go first for both of those issues together, and then claimant will do both 6 and 7. There will be a rebuttal after issue 3, and then there will be a rebuttal after 6 and 7.
Good. Thank you for letting the tribunal know of your discussion, which is very good and quite impressive. Makes the whole process much more efficient. Usually people can waste a bit of time on this different issues. Thank you again. Okay, good. Welcome to the final of the CETA Cup Investment Moot Arbitration 2021. And congratulations to everyone, each of the counsels who have made this far, advancing to the final, which is quite an achievement itself. I'm the presiding arbitrator, Bai Xianyue. I'm a managing partner of Grant Law Firm. And together on the panel, the Feng Han had just now introduced, but I'd like to mention their name again. On the panel together with me is Olga Botanko, Mr. Olga Botanko, and Mr. Zhang Xin from Global Law Firm. Usually, I would make a point of allowing the participating counsels to identify themselves, your name and your team number, without disclosing the university that you represent, of course. Please, can I invite the counsels for the claimant, please?
Yes, thank you, Mr. President. My name is Frederick Lindmark. I'm on team 30, and I represent claimant in these proceedings, together with my co-counsel, Jiang Xinyuan.
Okay, thank you. The counsels for the respondent, please.
Thank you, Mr. Arbitrator. My name is Guo Hongyi. This is my co-counsel, Zhao He, and today we represent the respondent. Thank you.
Thank you. A few housekeeping issues that I'd like to announce and clarify with the participating teams. So according to what was said just now, the teams have reached agreement on the 3 issues already, as well as the sequence of addressing those issues, and also time allocation, I suppose. And I would like to confirm with the respondent. So you do agree with what was said just now by the counsel of the claimant. Is that the case?
Yes, Mr. Arbitrator, we agree issue 3, 6, and 7, and agree the sequence the claimant has just mentioned.
Okay. And how about time allocation? How much time do you reserve for rebuttal?
Yes, Mr. Arbitrator, and we will spend about 14 minutes in making our submission and reserve 5 minutes for rebuttal.
I see. Okay. So how about, let me clarify with the counsels for the claimant. What's your proposal in terms of a time allocation for your own submission? Do you want to let the panel and the opposing party know this?
Yes, Mr. President, we reserve 17 minutes and for issue 3 and a 2-minute rebuttal for issue 3. And then for issues 6 and 7, we reserve 24 minutes and 2 minutes for the rebuttals. I think that adds up to 45.
Okay, thank you. So the role today is, in terms of timekeeping, each party will do the timekeeping for their opposing team. So it might be advisable for each of the team to take note of the time allocation that was just now mentioned by your opposing party, all right? And talking about timekeeping, this is a relevant issue that I need to discuss at the very outside of this session. That is, we do sometimes run over our allocated time because of the interruption from the tribunal, because of the interaction, the questions raised, etc. So the rule is the time used by the tribunal to ask for questions and the interaction with the teams will not be counted toward your time, allocated to each of the member of the teams, but that will be included in overall time for the whole session. And what happens, in the past few days and in virtually, well, I wouldn't say every, but most of the sessions, we do have cases where we have to extend the time a little bit because of the technical problems, because of the glitches of the internet, etc. And we would expect that to happen. Yeah, so please be aware of that. And also sometimes when it comes to timekeeping, it's not easy and very difficult sometimes to keep track of the time used. Again, because of the interruption from the tribunal and interaction with the tribunal. What I would do is, unless there's objection from the opposing party, as long as the two parties are okay with this, we will allow this to happen. Again, unless there's any objection, in which case the equal treatment principle would apply. Okay, and arbitrators throughout the session, again, as I said, will be and is expected to do so. Interrupt your submission, challenge your positions, and raising questions. So this is really a chance for the parties to seize, during which you may impress the panel, make your case more effectively. And also another issue that I'd like to bring to the attention of the teams is the tribunal will make every effort, to observe the principle of equal treatment, particularly in the case of interruption and interaction with the two teams. But it's virtually impossible to maintain an absolute equality in that respect. So nothing in the process of doing this shall be perceived as unequal treatment. Thank you. Now, shall we now officially start our session? And may we invite, according to the agreement the two teams have reached at the very beginning of the session, the counsel for the claimant to start with your submission with respect to issue 3. Counsel for the claimant, the floor is yours, please.
Thank you, Mr. President. Members of the tribunal, esteemed opposing counsel. My name is Frederick Lindmark, and I appear as counsel on behalf of the claimants in this case, together with my co-counsel, Jiang Xinyue. For the following 17 minutes, I will now address the respondents' objections to the tribunal's jurisdiction, rationale personae, over the Charlotte family's claim. Here, claimant makes 3 submissions. First, we will submit that Charlotte was a covered investor before 1819. Secondly, we will submit that Mr. Charlotte and his heirs are entitled to file a claim under the Vienna Investment Treaty, even after 1819. And third, that there is no requirement to show existence of damages, and in any event, that Charlotte has been, prima facie, a target of a measure which caused damage. Before I proceed, let me apologize in advance if there is some crying in the background. My nephew is having a tantrum, I believe. Okay, members of the tribunal, starting with our first submission, we submit that Mr. Charlotte was an investor from the time that Denis assigned half of his investment to him in 1813, and a protected foreign investor from the time that the Vienna Investment Treaty entered into force. Thus, he was a covered investor before 1819, contrary to the respondent's allegations in this case. Here, Mr. Denis was granted the concession to exploit the mine by a royal decree from France in 1806, which led to an exploitation contract between Denis and France. In June 1813, Denis transferred his mining rights under the contract with France to the joint venture Denis and Company, to which Charlotte then contributed 300,000 francs. And then they mutually set up together a 50-50 joint venture. On this point, members of the tribunal, we respectfully remind you that investments are freely assignable, and that also includes the present case. If we may refer the members of the tribunal to page 6 of the record, which is Article 7 of the 1810 mining law. I quote from the provision, "The perpetual ownership of the mine is granted, which is henceforth available and transmissible like any other property." This shows an acceptance that Denis could legally transfer his contractual rights of the exploitation of the mines to the joint venture, so that the joint venture owned the concession. So, by owning the 50% of the joint venture in 1813, Charlotte owned 50% of the concession agreement in 1813. This qualifies as an investment, both in form of Article 1b, subsection 2 of the Vienna Investment Treaty, but most notably subsection 4 in the Investment Treaty, which includes business concessions conferred by law or under contract, including concessions to exploit natural resources. And I've left out some words there relating to the maritime areas, because what we are here dealing with is other natural resources. In addition, Mr. Charlotte has always been a covered national under Article 1c, because he has always been a French national. Now, we do not disagree with the respondent's point that he sold his shares to the joint venture in 1819 to Mr. Mosselman, and Mr. Mosselman continued to operate the business from this moment on. What the respondents are arguing is that by selling these shares, he lost his status as an investor and that there is therefore no jurisdiction ratione personae. Which brings me to my second submission, which is that Mr. Schollert was still entitled to claim despite selling his shares in 1819. In order to explain my point, we first need to look at three key events here before I will provide a legal basis for our argument.
Counsel,
First,
Counsel,
yes.
I apologize for interrupting you. Could you please clarify whether there is a requirement for continuous ownership of investment in order for the claimant to have standing to sue under a relevant investment treaty? In other words, is there a requirement for continuous ownership of the investment in order to be able to?
Yes, Madam Arbitrator. Generally speaking, the question of the nationality needs to be determined at the time that the claim was filed. So that is usually the case. But as I will explain very soon, we will submit that in this present case, like in some other cases, there should be made an exception to this.
Isn't it often the case that an aggrieved investor would have lost property or ownership over his or her investment before filing a claim in investor treaty arbitration?
That would perhaps more often occur in terms of a business rather than a national, if that is what you're referring to.
All right, thank you.
Okay, thank you. Let me get back to these three key events that we'll go through first. In October 1813, France firstly sued Denis for the non-payment of fees under a dubious law from 1810. Secondly, in 1815 to 1816, Prussia and the Netherlands jointly took over the sovereign rule over Moresnet. Third, in early 1822, Prussia and the Netherlands decided to freeze the legal system of Moresnet, which is why they suddenly insisted on the additional payment of the fees from the 1810 law, in clear violation of the contract from 1806 and in clear violation of the promises in the Aachen Boundary Treaty, which I will also get back to. Because of this retrospective effect of the 1810 law, which happened from 1822, we need to look at the years of 1813 to 1819 through a new lens. Basically, because of an act made in 1822, Schollert's rights under the concession agreement and the Aachen Boundary Treaty were unilaterally and unlawfully infringed upon by the respondents' enforcement of double concession fees for each of these years. We submit here that when there is a case where the measure retrospectively targets a previous foreign investment, it is completely reasonable and absolutely necessary that foreign investors be granted the protection that they were entitled to at the time. The usual doctrine that jurisdiction must be assessed based on the investors and the investment status at the time of the notice of arbitration does not fit in these circumstances. Firstly, this is not the only place where such an exception is made in investment arbitration. For example, in cases of expropriation, it is self-evident and follows from it is logical that there cannot be a continuous ownership requirement from the time that the measure was taken until the time that the claim is submitted, because the investor has, by the very definition of expropriation, lost his investment and no longer is an investor. However, those cases are not barred from jurisdiction. If you lose your property due to an expropriation, you may still file a claim even though you technically do not own the investor anymore. And we submit that there are good reasons to adopt the same principle here, by analogy. Schollert had sold his investment, but the respondent still came after him with a retrospective judgment, which we submit amounts to an abuse of its position as a state and violated his previous foreign investment, just like is the case for unlawful expropriations. I sense a question.
Counsel, another question for you. Did the act of expropriation in this matter happen before the claimant sold his investment or after the claimant sold its investment?
Madam Arbitrator, in the present case, we are not actually arguing that it was an expropriation, first of all, but the measure in question did happen after the time he sold his investment.
So the contested measure was imposed on an investment project which the claimant no longer owned.
Yes.
Okay, thank you.
Well, I think I misspoke. Sorry, go ahead.
Yeah, I have one question as well.
Yes.
Let's go back to those three basic events you just mentioned about the timeline. Do you think there's a difference between the position between 1813 and 1815 or 16, when Morsnet was transferred to Prussia and the Netherlands, and the period after 1815 or 16, when Morsnet was changed to the other countries' tax? Would you please elaborate a little bit on that?
I will do that, but let me first clarify something, because I did misspeak to Madam Arbitrator. We are submitting that the measure that was taken in the present case happened in 1813 in this case, and that it has been a continuation of the same measure for the as in that the Dutch court's judgments were a continuation of the original measure that was taken when the French courts ruled in 1813, because that is when the dispute crystallized in the present case. Would you like me to clarify any difference between 1813 and 1816, Mr. Arbitrator?
Yes, please.
Yes. We submit that the dispute did start in 1813, because this is when there was a exchange of communication between the parties as to the legal and the factual differences between them. And we do not submit that the dispute arose in 1816. However, the enactment of the Aachen Boundary Treaty, which included Article 31, which I will also get back to, that gave a protection which we will also submit was violated under the Vienna Investment Treaty. Now,
okay, thank you.
Let me see. Okay, so now having established that, okay, let me actually get more into that before I move on. So what we are submitting is that the 1813 Act, the measures taken by the French courts, the measures that were subsequently taken by the commissioners of the mines in the years of 1822 and onwards, and the court decisions that were rendered in the years of 1826, 1828, and 1829. Those are a continuation of the same measure in this case. And what we are alleging is the measure, as I sense that the arbitrators are questioning what the measure is here. What we are alleging in this present case is that there has been a violation of the umbrella clause in the Vienna Investment Treaty. Let me now take you to Article 2 of the Vienna Investment Treaty, 2 subsection 4. It says in this umbrella clause that each contracting party shall observe any obligation it may have entered into with regard to investments of nationals or companies of the other contracting parties. This umbrella clause is an undertaking by the states who are party to this Vienna Investment Treaty that they will honor domestic agreements. In addition, we also submit that this article protects the investors for the promises made under the Aachen Boundary Treaty. So let me now take you to the specific commitment in the Aachen Boundary Treaty, Article 31. Which reads, sorry for the delay here. Any change in dominion of or government over the territory shall not prejudice the rights of Mr. Denis and company regarding the exploitation of the calamine, in that his concession will in all cases remain intact and will continue to enjoy the same advantages and privileges that were originally attached to it. What we are submitting is that this undertaking, which was a specific commitment to the company and also therefore to Cholet as the owner of the company, and the concession agreement in addition, the violation of these through the acts of the commissioners and through the court judgments of the Netherlands violated the umbrella clause of the Vienna Investment Treaty, which is the measure in this case. Now, I would like to move to my third submission, where we will also submit that we will respond to the respondent's allegation that Cholet was not a victim in this case. It is important to note that the objection on the basis of lack of damages is not a standalone ground for making any form of conclusion whatsoever. As stated by the tribunal in the Total SA versus Argentina tribunal, the claimant has requested a declaratory judgment that Argentina has breached the BIT. In this respect, the issue of damages is immaterial. As a consequence, the objection by Argentina, based on the alleged lack of damages, must be rejected. Secondly, as an even if argument, we submit that the demand for additional payment under the 1810 law, as I have demonstrated, was a prima facie treaty violation from the time of its enactment, from the time of its retrospective enactment in 1810, and has caused damages to Cholet and his heirs. Furthermore, the concept that was evoked in the case filed by the respondents, the concept of victim, has no place in investment treaty arbitration, but rather in human rights law. So we assume that they mean damages. For this part, of course, we will get more back to it in the merits phase. We submit that it is more than enough to establish that there has been a prima facie treaty violation to establish that Cholet has suffered damages. Again, in the words of the Total SA versus Argentina tribunal, the possible uncertainty as to the final amount of damages does not represent a bar to jurisdiction, but is rather an issue to be decided in the merits phase. Finally, before I conclude, I would also remind the tribunal that there is another article of the Vienna Investment Treaty that is very important to understanding the claimant's case. Article 12 of the Vienna Investment Treaty gives the treaty a retrospective effect made to investments made before the treaty's entry into force. It says that the treaty shall apply to all investments made before or after its entry into force by investors of the contracting party. Here, so it also covers the pre-existing investments. I see that my time is now running out, so I will quickly conclude my submissions. In conclusion, the claimant requests that the members of the tribunal find that it has jurisdiction over the present dispute and that Mr. Cholet, it has jurisdiction ratione personae over Mr. Cholet's claim. That concludes all of my submissions with respect to issue 3. Thank you for your time.
Thank you, counsel, for the claimant. Is there any question from the tribunal members so far?
Can I have one more question on Article
Yes.
12 you just cited?
Okay,
Could you
please.
please elaborate a little bit more on Article 12? Why is it relevant? If it's relevant to the investment, the covered investment, when was the VIT treaty signed? When was the covered investment established? Is there any relevance between these two?
Yes, the Vienna Investment Treaty was concluded in 1815. And as we know from the clarifications that were submitted by the Frankfurt Moot, the parties, Netherlands, Prussia, and Belgium, were all considered to be contracting parties to the Vienna Investment Treaty from the beginning. So we must assume that to be the case. In the present case, we know that Mr. Cholet's investment was made in 1813 when he became a co-owner of Denis and Company.
Can I interrupt you here?
Yes, of course.
When Cholet made investment in 1813 was French. And
Yes, Mr. Arbitrator.
Was Donny and Co. a French company as well?
Okay, I see your concern. First of all, the national who is the claimant in this case is Mr. Cholet. The company, Donny and C, is a issue that will be determined under issue 4. And this company, we will submit that it is a French company with a majority control by a French national, namely Mr. Cholet. And it follows from the case fact that Mr. Cholet has always been a French national.
Okay, understand. Thank you.
Okay. Thank you, counsel, for the claimant for your submission on issue 3. Unless there's any further question from the tribunal, may we now invite counsel for the respondent to make their submission on issue 3. Please.
Thank you, arbitrators, and thank you for counsel's argument about issue 3. I'm Jiao He. Today, I mainly present the issue 3 argument. And also, before the argument, in order for better comprehension to our following submission for the tribunals, may I please the tribunal to let me kindly send an abbreviation list into the chatting room. Now, at the very beginning, please allow me to introduce the main fact fairly with the screen sharing function in the Zoom, which is vital to determine the worth of the issue 3. So please to repeat our request. Now I'll open the function of screen sharing in Zoom. Dear arbitrators, now could you see clearly what I'm presenting in the pictures? Okay.
Yes, we can see it. Yeah, it's not extremely clear, but it's okay. Yeah, please proceed.
Thank you, arbitrator. Now, please allow me carefully to introduce the main fact fairly at the very beginning. The whole case, in our views, is about 1 mine, 2 companies, and 3 disputes. First, for the zinc mine of the Morsnet, which is located in Liège. As you can see, in the triangle area in the pictures, which means the French, which is the blue area in the picture, owned this mine and this territory until it was ceded in 1815 for the Napoleon defeat in Waterloo. However, due to the belonging and the benefit of the zinc and the neutral, there's no consent was made until Austrian-Belgian Treaty, which made the Morsnet as a special neutral space with no sovereignty and no sovereign rights, neither from the Netherlands, as you can see from the pink area, and the Prussia is now the German of the blue area. So let me stress this question again, that the Austrian-Belgian Treaty made the Morsnet as a special status with no sovereignty from the Netherlands and Prussia until the 1813, the Belgian independence. Namely, this area is non-territory of the respondent until the 1831. And now, about the 2 companies. As you can see, in 1813, the Donny founded a company named Donny Company. Hereinafter, I will call it the DNC for short. And also, he contributed his mine concession, which is granted by Napoleon. And also, the Charlie and the Belgian businessman Moselman are also the shareholders of the DNC. Eventually, for some reasonable reason, Moselman obtained 100% ownership and founded the Viel Moderna SA in 1837. and hereafter we will call this company as the VMSA for short. And also, there are two shareholders in the VMSA. One is the Billiken Bank, and other one is the Billiken family, the Musselman family. And also, in the fact, the VMSA is founded in Belgium after the 1831, which absolutely made the VMSA as a domestic company about the Belgium. Now, may I draw your attention to the vital part, the three disputes in our case. About the case, the first one is in 1825, binding by the judgment of French. The 1813, the judgment of the Liege is made by a French government to a French donning. And also, lastly, the Prussia and the Netherlands turned to the Court of Liege to sue the Musselman by Charlie to pay the fee they never paid. And that, in the proceeding of the mighty law appealing, the final judgment sustained. And now, eventually, Charlie and the Wimson submitted for an arbitration pursuant to our VIT against three states, which is the arbitration we are proceeding in this arbitration. The respondent would reserve no effort to protect the state interest and to pierce the claimant's camouflage of abusing international law. Now, I'll finish my screen sharing. Thank you, arbitrators. Now, dear arbitrators, may I draw your attention back to the issue we're talking today? And mine will be issue 1 arguing. And firstly, concerning issue 1, the respondent, concerning the issue 3, sorry, arbitrator, concerning the first issue, the issue 3, respondent will pretend that there's no jurisdiction, there's only reasoning of the challenge, and there's also no victim in the whole dispute. First, to argue there's no jurisdiction.
Counsel, I apologize. Before you proceed to that, and I know you have your order of arguments, but I have a question regarding the chronology of events in this arbitration, in particular in terms of personal jurisdiction and the claimant's ownership in the investment. Based on your submissions and based on the claimant's counsel submissions, I understand that there are 3 crucial time points that are important and relevant for the personal jurisdiction over the claimant in this arbitration. First is when the investment was made. Second, when the contested measure was taken. And third, when the claimant filed its notice of dispute. From what I understand from the claimant, and given that you responded and you're coming second, I would appreciate addressing the claimant's arguments. On the third point, the claimant's standing in terms of personal jurisdiction at the time when the claim is filed, the parties agree that the claimant owes nothing in the investment project, that the claimant has lost its property, its invested property. In this regard, the claimant argues that there is no requirement of continuous ownership in investment law in order to be able to have standing to file a claim of this nature. So I think we agree on that. In terms of the 2 other crucial points in time, the time when the measure is taken and the time when the investment was made, could you please clarify, at the time when the contested measure was taken, was the claimant an investor within the meaning of the treaty? And also with respect to the time when the investment was made, at the time when the joint venture was finalized, was the claimant an investor within the meaning of the treaty?
Thank you, arbitrator, and thank you for asking. The question you just raised is also the one I'd like to raise in the following statement. But for answer you, I'd like to put it first to answer you. And if you understood you correctly, there are 2 main questions you just raised. The first, the property, and also that is the shares of the or the control of the claimant made in the territorial or the respondent. And the second question is the measure, how to define the measure taking place, the timeline, and also with the relationship between the measures and the investment. And I'm so glad that you mentioned there are 3 time points. However, to answer you more actually, there are 5 important time points in our case. So I'd like to introduce the whole 5 points to better answer you about the investment made by the claimant. About just you said, the Donny Company, we short for the DNC, was made in 1813, and the Donny Hector and the Charlie Hector, they have the 15 to 15 shares to establish the Donny Company, which means in 1813, they have the 50% control or 50% of shares for Charlie to the DNC. And then the time trace to the 1813, the October. The Donny and Hector, they are still the shareholders of the DNC. However, in this timeline, the Musselman, as a bill game businessman, came into these judicial vehicles, and he obtained about the 37 shares for the whole companies. And in this time point, the 1813, the Donny still have 20.5 of the shares, and the Musselman obtained more than the 35 shares of the DNC. And now, which is a very vital timeline that I want to mention in the following. In 1819, the Donny went bankrupt and sold his whole interest and share to the Musselman. And followingly, at the same year, the Charlie, the claimant in our case, also sold his interest to Musselman and left the joint venture, which means in 1819, the Charlie is no longer an investor to the DNC, and we haven't talking about the DNC's investors qualified or not. We just wanted to explain the timeline and the whole investment. And also, just like I just said, after the two mine investors have left from the DNC family, the Belgian businessman Musselman has obtained the 100% of the DNC, which means the DNC has been controlled by Belgium. And now, we'd like to mention that there's just like I just mentioned, there are 2 companies. There are 2 personalities of the companies. In 1837, after the Musselman had the total control of the DNC company, he merged the DNC into a new company named Viel Magna SA, which will be short for the WIMSA, the WMSA. The Musselman family and the Bank of the Belgium founded the WMSA in Liège. And also, the family DNC had merged into the new created SA when SA was created. And what I want to stress that is eventually, Donny is no longer an investor, no matter of the DNC or the WMSA at the point of 1819. And also, I want to comment with the question another arbitrator just raised for the claimant that it's true from the 1815 or the 1816, the Argentine Treaty has stipulated the territory of the Musselman is not cleared as a neutral area, but is co-administrated by the respondent, which means after 1815, the shares of Donny shared. The shares of Donny controlled became a domestic investment. And also, if you have no more further question, I'd like to move to the second question you just raised about what's the relationship between the measures, that is the judgment, and the timeline I just mentioned. Actually, it's very interesting because during the same fact of the case, however, we found a total different view about the measures and the crystallize of the measures in the case. Family, the time and the dispute, in our view, is cannot be identical with time and event leading to the dispute, because a dispute request not only have the development or the degree. However, in this case, in 1813, judgment of the liege only to make the concession payment, which the Charlie, as the respondent of our case, is not the one to pay or not the one to be damaged. And also, we'd like to redress the one issue I just stressed in the introduction of the story, that the first issue, just as the claimant just mentioned in 1813, this dispute is about a French government to sue a French named Donny, which named the 1813 dispute can now be seen as the origin of our whole case. So if there may please you and may please you to let me proceed with the issue. Thank you, arbitrator.
Okay, thank you, counsel, for your submission on issue 3.
Sorry, arbitrator.
Shall we? Okay.
Sorry, arbitrator. The following question is just to answer the arbitrator's question. So I haven't. I'm sorry. So sorry to misunderstand you.
I'm sorry. Please proceed.
Thank you, arbitrator. So to argue the non-jurisdiction rational personality of the Charlie, there are 3 reasons in case we can find to prove. Firstly, the Charlie had no qualified foreign investment. Now, may I kindly draw your attention to the page 32 of the case. In page 32, the 4th paragraph, it was George's and Robert Charlie who actually submitted for an arbitration as the sons of Charlie Hector. And they never had any investment according to the case, as the VAT limits its application to foreign investors. Therefore, the claimants are not qualified. Secondly, of course, just as the claimant just mentioned, we can also assume that the identity of Hector Charlie can be succeeded. However, the claimants are still not qualified investors because the Hector Charlie was not a qualified one. In Exceed Tribunal's practice, there are more than 5 factors to determine a qualified investor, and also cabining the rating of the VAT preamble, including the contribution to the host state. However, what we want to stress is that the Charlie's investments failed to satisfy this condition because the benefit and also development of the economy did not contribute to our host state. In our case, the Charlie's investment established in Morsnet, which was not a territory of any respondent, and also none of the respondent was the host state. Moreover, according to the case, there was no tax on the Charlie's investment, and the mining fee was also rejected by the claimant. Overall, and there also all the factors reflected this issue, and etc. Overall, without the contribution to the host state, the Charlie had no qualified investor. And also, thirdly, there was no jurisdiction versus only personality of Charlie because Charlie seemed to be an investor because the dispute taking place in 1826 instead of the claimant mentioned 1813. Now, may I draw attention to page 12 of the case. As you can see in 12 of the case, the paragraph 5, Charlie has left the company in 1819. However, the dispute can trace back in the early 1825, which I had just explained formally, as the major latest judgment on Charlie were made. Lastly, just as the arbitrator just questioned for the claimant, as Charlie's vehicle, Donny and Company, DNC was no longer a foreign company after the 1816. Now, may I kindly draw your attention to the page 22 of the case. As you can see, the claimant, the place Donny's investment constantly operate, was no longer a French territorial due to the city, but the area administered by the respondent. Moreover, the Muslim turned to the territory of the Belgian after 1871, namely, the investment has fallen into the respondent's domestic one. Therefore, as DNC had territorial domestic companies, the tribunal has no jurisdiction to the investment for Charlie. In conclusion, the tribunal has no jurisdiction over owning personnel of Chalet because its investment is not qualified. Now, also, may I draw attention to the second problem we'd like to solve in whole issue 3, the victim of the dispute. Just as the claimant just said,
I'm sorry to interrupt, counsel. Sorry to interrupt, if I may. Just a follow-up to your answer. Before 1815 or 16, Donny and C was a French company, as you just submitted. After that, it was a Belgian company or another company which was not a French company. But before 1815, it was a French company. Would that fact have any impact on your submission? Could you please elaborate a little bit more on that point?
I'm sorry, arbitrator. Due to the poor signature, we can't hear you clearly as we can. So, I kindly please you to clarify your question again. I'm so sorry about it.
Fine. So, before 1815, Donny and C was a French company. Would that fact have any impact on your arguments? Could you please elaborate that?
Thank you, arbitrator. Thank you so much for kindly repeat. In our view, the 1815 and the 1816, as the Mosnet is a French company, we'd like to say it did have some impact greatly to our case argument, because in 1815 and 1816, the French company, the DNC, was founded by the French one, the Charlie, to invest the French to their home state, which means I don't think it's in foreign investment in international law in our case. So it's a domestic investment between the French and the French guys. And also, we'd like to clarify our question again, is that we think the timeline before the 1823 is not that irrelevant, because in our view, the dispute can earliest trace back to the 1823 instead of the 1829 before. So the nationality and also the investment and also the control should be determined after the timeline of the 1823. So may proceed, and may I question please you, the arbitrator.
Please go ahead. Thank you.
Thank you so much, arbitrator. And now I'll continue to argue about the second problem in issue 3. Now, may I draw attention back to the victim of the dispute.
Sorry, opposing counsel. May I interject? I think you have spoken for approximately 20 minutes. I think you allocated 14 minutes for the issue 3. And I have also paused when the arbitrators have spoken. So I just wanted to make you aware of that. Sorry for the interruption.
Thank you so much, dear opposing counsels. And thanks so much for your mention that I will conclude to my final issue. That, of course, we'd like to mention first that there is the concept of the victim in the international law and international investment law. And also, even though we can assume that the Charlie are able to invoke the VIT to submit an arbitration due to his damage. However, the Charlie did not suffer any damage pursuant to Article 36 of LLC. The Article of LLC limits the situation of being damaged should be limited to the financially assembled damage. In practice, the standard of exceed and the PCA tribunal noted that the damage should be the financially assembled damage, which is including 2 factors, the foreseeability and the sufficient certainty. However, combined with the 2 factors together, because they're the poor timing, and as I just wanted to draw your attention to the case that you can see in the page 35 of the case.
Also, I'm sorry to interrupt you. I think Now that your opposing party has challenged the time that you've run over, the very fact which you should be aware of, I would encourage you to conclude as soon as possible in the next 2 minutes, okay?
Thank you, arbitrator. Then I'll jump to the close. Thank you, arbitrator, for your explanation. Well, for the condition to establish the damage, it should be two conditions to establish: the sovereignty and also the foreseeability and the certainty. However, according you can see from the page 35 of the case, the claimants are submitting for the damage from the fear of execution, which is way too subjective because the laws never exist and is possible to foreshaw. Therefore, the challenge law is not foreseeability and not also a certainty. Lastly, we'd like to kindly remind the tribunal that, as a previous, the obligation under the law is a necessary one. However, just we submitted an issue, the mootness was not the territory of the respondent. In a word, the respondent has no obligation to provide a method to remedies, no bother to determine the damage at all. So, thank for the mention of the opposed counsel and the arbitrator. In conclusion, there is no jurisdiction, rather only personally of the challenge, and also there is no victim in the whole dispute. Thank you, arbitrator. I raise my statement of the issue 3.
So you've concluded finished your submission, yeah, for issue 3, counsel for the respondent, yeah?
Yes,
so
arbitrator.
May I now invite counsel for the claimant to make your rebuttal, and also, do you have any request for the benefit of equal treatment, and do you require additional time equivalent to what the counsel for the respondent has used just now, please?
Mr. President, before we move on to our rebuttal, we would like to just point out that they have spent so far 24 minutes out of their, in total, 45 minutes. So we would request that they now, for the remaining 21 minutes, they distribute them according to how they would like to use them for the rebuttal, issue 6 and 7, and the rebuttal at the end.
Okay. So counsel for the respondent, you have heard what was said just now, yeah? So be aware of this.
Thank you, Mr. Arbitrator, and thanks the opposing counsel. And I will reserve 1 minute for my co-counsel to rebuttal for issue 1. And the rest of the time, I will use for the submission concerning issues 6 and 7. Thanks.
Okay. So you don't have any issue with that challenge, right? Or and the request from the counsel of the claimant. You're agreeable with that request, do you? Don't you?
Because my co-counsel has made answer the Madam Arbitration's question. So if we consider it appropriate, we will also request 1 minute for a brief conclusion of all our 3 submissions. That's my request. Thank you.
Okay, fine. Okay, let's give the floor to the counsel for the claimant, please, for your rebuttal.
Yes, thank you, Mr. President, members of the tribunal. The respondent has raised every single objection that they could imagine. So I think I will be brief and I will only address 3 points. First of all, they have been mixing together the companies and the national Mr. Shawley. Under issue 3, we are debating whether Mr. Shawley, a personal investor, and his heirs, who are also individuals, can claim, not the nationality of the companies under issue 3. Secondly, they have mentioned that the territorial jurisdiction over Moresnet, that the Prussia and the Netherlands and Belgium did not exercise sovereignty over this area, that it was I believe they said a independent state in the very beginning of their submission. However, as we know, in the final act of 8th of June, 1815, these states wanted to have sovereignty over it, and they concluded a plurilateral boundary treaty for all of Europe. And after that, it turned out that they both had claimed sovereignty over this area, which resulted in the Aachen Boundary Treaty, which is a boundary treaty that also shows that they have exercised sovereignty over it. In addition, they are suing the claimants in the Liège courts. How can they sue the claimants in the Liège courts for territory that is an independent state? For acts that were for the alleged law that was rendered by themselves in an independent state in a foreign court? It doesn't really make sense. Finally, I will address that the Liège court judgments were against Denis, as they have stated. Yes, that is indeed true. But however, as I already mentioned in my speech, Denis was legally allowed to transfer the concession agreement into the company. And before the 1813 judgment, Denis had transferred all of his ownership into Denis & Cie, which meant that the real owner of the company, when the 1813 judgment, the real owner of the concession was the Denis & Company. That concludes my rebuttal. Thank you, members of the tribunal.
Thank you, counsel, for the claimant. So before we move on for the third rebuttal from the respondent, I'd like to seek the opinion of my co-arbitrators on the panel regarding the time issue, the time allocation issue, and the request from the counsel of the claimant just now. Mr. Zhang and Olga, Mr. Bentenko, do you have any different opinions or any comments on this request?
So long as the claimant accepts the respondent's, so long as the respondent accepts the claimant's proposal, I'm fine for that.
Okay. So, Olga Bentenko?
I agree with that. I think it's quite fair. And from what I understand, the time for the tribunal questions have been taken out of the time calculation. So it would only be fair to allocate the time that way if the respondent agrees.
Thank you. Exactly. That is exactly the rule and the idea. Okay, thank you. Thank you for your input. And let's move on to the respondent for your rebuttal to what has been just now submitted by the claimant. Please.
Thank you, arbitrator, and thank you for my procedure of rebuttal. First, after hearing the submission of the claimant, I submitted the 5 issues to against the rebuttal time, and I will submit it one by one. First, as the claimant submitted, the whole dispute should trace back to 1813 instead of 1823. However, just as the whole dispute and whole story I just mentioned in my submission, the earliest of the trace back to privilege should to the 1823 instead of 1813. And also for the second issue, that the claimant mentioned the umbrella clause. However, we'd like to mention that the umbrella clause is only protected as an umbrella to the subjective in the VAT, which is a foreign investor. However, he also mentioned the Denis and the Charlie and also the DNC company are not the foreign company but a domestic one. And also for the third question, the treaty claim, if can be succeeded, which is the key issue of the claimant. However, we think it's not the key issue we arguing today, because even the treaty claim can be succeed, the investor are still not a qualified one because it's domestic company. And lastly, I want to remind that the Article 12 of the VAT, which is limited to the VAT, is that of the relevant to our case. So in the respondent conclusion that there's no jurisdiction right only and personally to the Charlie. And also, there's no team in the whole case because they lacked the satisfying the conditions of the victim. Thank you, arbitrator.
Counsel, I have a question for you. Did you say, I kind of just want to confirm with you, did you say that a VIT should not be applied to this case just now? So did you say the VIT doesn't apply?
Mr. Arbitrator, thanks for your question. My co-counsel had just indicated that the VIT should apply to this case.
Okay, fine. Another question, how do you define crystallization of a dispute? Is there a criteria and how should it be applied to this case?
Yes, Mr. Arbitrator. According to what my co-counsel had just indicated, that the crystallization of the dispute indicates that the Netherlands and Prussia agreed to use the Napoli Code in the neutral Morsnap, and that is the crystallization because the regulation of law has been crystallized dating back to the French time.
Okay, thank you. Unless there's any further question from the tribunal, we'd like to invite, according to the agreement between the parties at the very beginning of the session, the counsel for the respondent, to move on to issue 6. So, counsel for the respondent, the floor is yours.
Thank you, Mr. Arbitrator. My name is Guo Hongyi, and I will take charge of issue 6 and issue 7 for the respondent. Concerning issue 6, the respondent submits that the tribunal is not empowered to undertake a joint arbitration, and there I have 3 reasons to discuss. First, the treaty silence in Article 8 of the Vienna Investment Treaty does not empower the tribunal to include 3 countries in one arbitration. According to international treaty thesis, the treaty of silence means that there is a qualified silence or there is a gap.
Counsel, I'm sorry to interrupt you. I'm kind of challenging your position on this issue. So you basically said VIT does not allow multi-party dispute resolution. Is that the point you were trying to say?
Yes, Mr. Arbitrator.
So why is that the case? Which provision, what are the provisions that provide, anything to that effect?
Yes, Mr. Arbitrator. Your question is just what I want to discuss in my 3 reasons. The first reason is that there is a treaty silence according to Article 8, Paragraph 3 of the Vienna Investment Treaty. And the Article 8, Paragraph 3 of the VIT indicates that the parties should refer the case to ECIT or the PCA court. And thereby, we should know that there is second question, what is the prescription of the PCA rules? And according to our research in the PCA rules, there is no multi-party arbitration agreement unless there has been established a mutual agreement between the parties. And the third reason, if I could briefly conclude, is that the present tribunal lacks the necessary impartiality and fairness for the present submitting.
Counsel, on that, I have a very brief question before you proceed to your next topic. You make reference to the VIT in terms of determining whether it allows for multi-party arbitration. The question is VIT designed to provide procedural framework for the arbitration, or is there any other legal instrument, such as the PCA arbitration rules, that would provide such procedural framework to the arbitration?
Thank you, Madam Arbitrator. Your question, may I draw your attention back to Article 8, Paragraph 3 of the Vienna Investment Treaty. And according to that treaty, in that case, the VIT had just indicated that the parties, they should settle the dispute through 2 channels of the organization. The first he mentioned is the UNCITRAL, and the second is ECIT. And the third is a permanent court of arbitration, which in our case is the PCA. So responding to your question, we believe that the VIT prescribed about the substantial rights about the investment for the investor and the host state. However, the Article 8 is a dispute resolution clause, thereafter prescribing relevant clauses to referring the case procedural problem to PCA rules. Thank you, Arbitrator.
Okay, thank you. Please proceed. Any further question from Ms. Olga Potenko?
No, thank you.
Thank you, Madam Arbitrator. If there is no more questions, I'll proceed. And as I have just mentioned, that the PCA allows multi-party arbitration only when there is an agreement. However, in our case, there is no such agreement. I have 3 reasons. The reason 1, the introduction of the PCA rules put party autonomy as a prerequisite of the multi-party proceeding. According to the introduction of the PCA rules, Section 3(8), the PCA rules emphasize flexibility and party autonomy, and then give an example of the multi-party arbitration. And we believe that the prerequisite is that the party autonomy. However, in our case, there is no such agreement between the claimant and the respondent, and the claimant's proposal about the joint arbitration is not sufficient to establish such courts. And the second reason is that alternatively, the VIT is an arbitration agreement. There is no any supplemental consent to this arbitration. And as we know that since there is no agreement in the VIT and there is no supplemental agreement beyond the VIT, then there is no agreement for the joint arbitration's establishment. And there is also, yes, Mr. Arbitrator, do you have any question?
Yeah, Counsel, I'm aware that you probably will cover this in issue 7, which I guess you will move on to in a few minutes. But still, let me raise this question regarding your position just now. I think I agree with you on your position regarding the PCA rules, yeah, which requires the agreement between the parties for a tribunal composing, more than 3 arbitrators, yeah. So do you think there's any issue that the tribunal should be aware of, considering the fact that the arbitrator appointed by the appointing authority, Mr. Zawanowski, yeah, appointed on behalf of the respondent, I think, yeah. So do you think there's any legal ground for the tribunal to kind of be aware of, because there's apparently some practical difficulty, yeah, for him to traveling to attend the hearing of this case? Do you think that we have any impact on this?
Yes, Mr. Arbitrator. As you have just mentioned, that your question relates to the issues in issue 7. I would like to refer next, and I will just briefly answer you. In order to answer your question, if I understand you correctly, you mean that in this case, the respondents, their arbitrator, Mr. Iwanowski, has ever raised concern over his ability, and then is there any legal impacts on this concern? And in order to answer your question, I would like to draw your attention to Article 12 of the PCA rules. It is about the challenge of the arbitrator. As we know that in the traditional paradigm, that the challenge against the arbitrator is from the parties of the arbitration. However, in this case, we have discovered that it was Mr. Arbitrator, Mr. Iwanowski, has raised his concern over his own capacity, which we will respondent will believe that the arbitrator believes that he has not the independence and has not the impartiality and has not the capacity to guarantee his role in this arbitration. However, according to the Mr. Solomon, which is the president of this tribunal, has replied that he will go forward despite obstacles, and that courage breeds creativity. And we believe that this kind of the rejection against this kind of the challenge, it is in violation of the Article 12 of the PCA rules, because it doesn't follow the appropriate procedure for rebuttaling to a challenge against an arbitrator. And we believe that the present tribunal is not inappropriate for the respondent's interest. Thank you, arbitrator.
Thank you. Please proceed.
Thank you, arbitrator. And there is a third dimension I would like to mention, that you violate respondents' procedural rights in this joint arbitration. There are also 3 reasons. Reason 1, the respondents' rights are not paralleled or not aligned. And in this section, I would like to refer a case to the tribunal. It is an ECIT case named the corn products versus the Mexico. And actually, in this case, there are 4 claimants. The Mexico government sued 4 claimants, which is the CPI, ADM tax, and lie, which indicates that Mexico government want to form a consolidation. And tribunal, the consolidation is kind of like the joint arbitration in our case. However, the ECIT tribunal, they just rejected this kind of the consolidation, claiming that the 4 claimants, their interests are not aligned and not paralleled. Thereafter, you will not be fair and efficient for the claimant. And arbitrator, I will draw your attention back to our case. In our case, there are 3 respondents and their interests are not aligned. Thereafter, we believe that the joint arbitration should not be allowed. There is also reason 2. If we insist on the joint arbitration, the right to nominate respondents, their own arbitrator, their rights will be violated. There is also a case. It is the ICC case, namely the Ducto versus BKMI and the Siemens. In this case, the ICC's arbitral awards has been cancelled by the French Supreme Court for the reason that they just violate the BKMI and Siemens, their own rights to appoint their own arbitrator. And the ICC believes that the principle of the equality of the parties in the designation of arbitrator is a matter of the public policy. And the respondent has their own right to appoint their own arbitrator. And dear tribunal, in our case, according to page 33 of this case, in the first instance, that the respondent's 3 government make no appointment with the time limits prescribed. Namely, the Secretary General of the PCA has appointed Mr. Aronofsky for the 3 respondents. And respondent submits that this kind of action that is severely in violation of respondents' rights to appoint their own arbitrator. Finally, there is also the case you just mentioned that the present arbitrator, Mr. Aronofsky, has challenged, and this kind of a challenge has not been properly settled down. Thereafter, we believe that a joint arbitration is not appropriate. Thereafter, the present proceeding has not the power to establish such kind of a joint arbitration. If there is no more question, I will jump to my analysis on the issue 7.
I do have a very quick question, and I think the council will be able to address it very fast. And the question is, if the parties do not agree on a procedural matter in the arbitration, such as, for example, whether a multi-party arbitration may be conducted, is there anything that would prevent this tribunal from deciding that disagreement? And I refer, in that regard, I'd like you to address Article 17 of the PCA rules that says that the arbitral tribunal may conduct the arbitration in such manner as it considers appropriate. So if this tribunal considers appropriate to have 3 respondents in this arbitration, is there anything that would prevent this tribunal from deciding to do so?
Thank you, Madam Arbitrator. As you have just mentioned, that the PCA rules that allow the Secretary General of the PCA to jointly nominate the one arbitrator for several respondents. And actually, respondent submits that it has the case to prevent the tribunal, which indicates that if the respondent, their interests will be severely violated. And the first thing is party autonomy, as you have to say. And the second, we believe that it's inappropriate to include 3 respondents in one arbitration. And we believe that this kind of the separation of the interest will be the thing that prevents this kind of the joint arbitration. Thank you.
In what ways, counsel, kind of follow-up question, in what way you mentioned about the violation of the party's autonomy, and the question from the tribunal is whether Article 17 itself is sufficient to empower the tribunal to make appropriate decision regarding the composition of the tribunal. So how do you reconcile these two different principles that seemingly all make sense and all are relevant? So how can you reconcile these two? Thank you.
Thank you, Mr. Arbitrator. According to Article 17, Paragraph 5 of the PCA rules, there is a regulation about the joiner. And we believe that the joiner, it is kind of like the joint arbitration we are proceeding. And according to Article 17 of the PCA rules, indicates that the joiner shall not be permitted in case of prejudice to any of those parties. And in this article, the prejudice to any of the existing party, it is the thing that will prevent such joint arbitration. And if I understand you correctly, you mean that is there anything that will ease the problem of the unparalleled interest of the parties? Then I will indicate that it is the PCA Secretary General, they have the rights. However, we believe that this kind of the party autonomy should be put prior to for the efficiency of the joint arbitration. And if I understand.
Yes, I'm sorry to interrupt you. So you mentioned about the risk of a prejudice, against any of the parties involved in the dispute. Who do you think should bear the burden of proof to establish the presence of a prejudice?
Thank you, Mr. Arbitrator. You have just mentioned that the burden of proof, and we believe that the parties, their interests who are violated, they should bear the burden of proof. And in our case, it is the respondent.
Thank you. Please proceed. Have you finished your submission on issue 6? You did, right?
Yes.
Okay, good. According to our agreement, and the procedural arrangement that we agreed at the outside of the session, shall we now invite the counsel for the claimant to make your submission on issue 6 as well? Counsel, for the respondent, you have any questions?
Yes, if I just, as we have negotiated with the claimant, we have decided to put issue 6 and issue 7 together, and then our rebuttal altogether.
I see.
Sorry.
So counsel for the claimant, that's the agreement, isn't it?
Yes, this is our agreement.
Okay, fine. I'm sorry. Thank you. Counsel for the respondent, you may now proceed.
Thank you, Mr. Arbitrator. Concerning issue 6, the respondent submits that the tribunal should be recomposed. And there are 2 lines. First line is that there should not be a joint arbitration. There should be 3 parallel arbitration. This is the first method for this kind of recomposition. And the second is that the present arbitration, they should consist of 3 arbitrators for each of the respondent. And I will begin my submission in the following. For the first line, respondent submits that the respondent, their dispute with the claimant is not basing on the same facts as the claimant had just indicated in their memo. That indicates that the respondent, their interests are the same and the measures is the same. Thereafter, we should combine the joint arbitration altogether. However, I also like to mention the fact that the Netherlands, the Belgium, and the Prussia, their interests are not the same, and they are not bringing claims from the claimant for the same reason. As we know, that it was Netherlands and Prussia that go to the Urge courts in 1825, and it was Belgium and Prussia that go to the French courts for enforcement in 1837. And as we know that the Belgium got independent from the Netherlands. Thereafter, we believe that it is not based on the same measures. There is reason too, even it is based on the same facts, or even it is based on the different facts, the multi-party arbitration, they should held in parallel instead of the present joint arbitration. And there is also a case I would like to refer to the tribunal. There is an unseature case of the CME and Lauder against the Czech Republic. In these two cases, there are two investors and there are two arbitration proceedings. And one investor lost its case. However, another investor owned a worth of $300 million from the Czech Republic. And the tribunal involved held that the parallel proceeding relating to the same facts were admissible on the grounds that nominally the parties and the two BITs involved were different. Tribunal, as I had just indicated in my previous issue, is that the measures of the respondent, they are not the same. Thereafter, referring to the unseature case, we believe that even for the different facts, that there should be a parallel arbitration instead of the present joint arbitration. Second, respondent should have the right to appoint their own arbitrator. There is also the ICC case of Ducto versus BKMI and Siemens, as I have just mentioned to you in issue 6. In the second dimension, if the claimant insists that there should not be parallel arbitration, the respondent submits that the present arbitration, there should be 3 arbitrators respectively for each of the respondent. And there are also 3 reasons. Reason 1, Article 10, paragraph 2 of the PCA rules allow the tribunal to be constituted with more than 5 arbitrators. According to the PCA rules, there is a quotation, quote, if the arbitration is composed of a number of the arbitrators other than 1, 3, 5, the arbitrators should be appointed according to the method agreed upon by the parties. And as we know that there is a possibility for the tribunal to be consist of arbitrators more than 5 persons. Secondly, it will be more flexible and more fair for 3 arbitrators. And according to Article 5 of the International Center of the Dispute Resolution.
Counsel, for the response, I'm sorry to interrupt you. You are talking about the provision of Article 10 under PCA rules, right? It does provide a possibility for the tribunal to be composed of more than 1, yeah, other than 1, 3, and 5, right? That would possibly include 7, yeah? That's true, but if you read through the provision, yeah, of that particular article, you need to have a prerequisite condition to be fulfilled before we can talk about that possibility. That is the presence of the agreement of the parties, yeah, or any other method agreed upon by the parties. But in this case, do we have any presence to that effect? Any agreement in that effect? If not, then what is the point of referring to that provision? Purely a hypothetical possibility?
Thank you, Mr. Arbitrator. The reason why I'm referring the Article 10 of the PCA rules, it aims to indicate that, yes, the PCA rules allow the arbitration consisting of arbitrators, more than 5 arbitrators. And this referring is just in responding to what the claimant had just brought. And the claimant had just indicated that it's impossible to find 7 arbitrators. And my reference about the PCA rules, it just indicates that there is the possibility. However, drawing your attention back to this case, there has no such agreement made between the claimant and the respondent. Thereafter, we believe that this kind of the possibility, it has only the reason to responding to what the claimant's intention. And may I also address that the recomposition of the arbitration is based on the value of the parallel arbitration. Thereafter, respondent will least likely to take of the 3 arbitrators respectively. If I understand you correctly, may I proceed, arbitrator?
Yes, please.
Thank you, Mr. Arbitrator. And finally, I will come to my last point, is that this present tribunal is not independent, as this is the fact of what Mr. Arbitrator had just mentioned, is that Mr. Awanowski lacks the necessary impartiality and independence. And that rests my submission. We conclude that in issue 6 and issue 7, that there should not be a joint arbitration. And if there have insist on joint arbitration, then the present arbitration, they should be recomposed and divided into 3 parallel arbitration. If there is not, and alternatively, we should have 3 arbitrators respectively for respondent each. Thank you, Mr. Arbitrator. That rests my submission.
Thank you. Thank you for, hold on. Yes, thank you for your presentation on issue 6 and 7. Are there any follow-up questions from my co-arbitrators on the panel at this stage? Okay, thank you. According to the agreement between the parties, now shall we now invite the counsels for the claimant to make their submission on issue 6 and 7, please.
Yes, thank you, Mr. President. Mr. President, members of the tribunal, as my co-counsel has introduced, my name is Jiang Xingyue. I appear before you as counsel on behalf of claimant, together with my co-counsel Frederick Lenmark. I respond to respondents' objection to the joint arbitration against all 3 respondents. Here, claimant makes two submissions. First, we submit that there is the consent to joint arbitration in the provision of VIT and PCA rules. Second, we submit that the disputed measures invoked by the claimant are against all respondents. First, I would like to give a quick response to the respondent's submission on the conditions to conduct a joint arbitration. Respondent just spent lots of time to illustrate that there should be parties' agreement to conduct a joint arbitration. However, we would like to point out this is irrelevant to our case. What we have here is not the issue of consolidation nor the joinder. What claimants are arguing is a purely multi-party arbitration, which means the co-respondent in one dispute. This concept must be distinguished, members of the tribunal. Here, in our case, claimants admit that there is only the same one dispute and the same one set of facts between claimant and 3 respondents. The claims are not filed on a separate basis and later aggregated, but filed on an aggregate basis from the beginning, which means that what we have here is the original submission of a claim by a plurality of respondents in one single proceedings. This leads to our first submission. We submit that there is no requirement of specific consent to joint arbitration. Even if there is such a requirement in our case, there is the parties' consent to joint arbitration in the provisions of VIT and PCA rules. First, we respectfully remind the tribunal that Article 8.3c of VIT specifically provides for arbitration under the PCA rules, which means that the parties have accepted the application of a set of rules that permit multi-party proceedings provided by PCA rules. For instance, the introduction of the PCA rules states that the rule allows for arbitration of multi-party disputes involving a combination of states. In addition, Article 10.1 of the PCA rules even provides for a procedure to appoint arbitrators in multi-party situations. Second, actually, there are many cases show that the specific consent of the party is not required to proceed a pure multi-party arbitration. The Tribunal of Guy and Rulik versus Bolivia case hold that the lack of specific consent in the BITs to join arbitration shall not bar joint arbitration because one cannot use silence to limit the scope of the consent to arbitration given by respondent in the treaty. Moving to our second submission, we submit that the disputed measures invoked by the claimant are against all respondents. First, I'll respond to respondents' submission that the respondents' interests are not parallel. Actually, what we have here, there's no need for respondents' interests to be parallel to conduct a pure multi-party arbitration in one dispute. That's a requirement of consolidation or joinder. Indeed, members of the tribunal, please allow me refer you to the case clarification from Frankfurt Commission on the page 8, paragraph 34. It says that to the extent the interests of the respondents coincide, it is clear that there's the respondents' interests are aligned. Even if there's such no clarification, claimants submit the respondents' interests are closely connected because they take the measures jointly. They all pursue to enforce the court's judgment, which results in claimants' damages. Respondents all argue that claimants are obliged to pay the mining fees and they are all seeking the same thing. They want the money. Second, the tribunal should be aware that the joint arbitration will not breach due process and the respondents' procedural rights will remain intact in the joint arbitration. In case Noble Energy versus Ecuador and Ambient versus Argentina, the tribunal both decides that it appears fair and respondents' procedural rights will not be impaired in the multi-party arbitration. To be precise, respondents argue that the principle of equality of the parties is violated when the claimant are able to choose its desired arbitrator while the co-respondent are not. Actually, as I just mentioned, what we have now is not the consolidation or joinder. Our case is about the purely multi-party arbitration in one dispute. Here, respondents are a combination as a whole. The co-respondents' rights to appoint their own arbitrator will not be deprived. Besides, there is the same situation that two claimants are faced with. Two claimants are jointly appointed one arbitrator, who is the Mr.
Also, I'm sorry to interrupt you. Yeah.
Yes, Mr.
So
President.
you're talking about this case at hand being a multi-party dispute, yeah, arbitration. What about, for example, because as you just now said, consolidation is also available. What about the tribunal giving its consent to a parallel proceedings to be initiated by the for example, by different proceedings and parallel proceedings, yeah, like three or at least three or several to go forward, and then at a later stage of the proceedings, then having those different parallel proceedings consolidated, would that be also an option available to the respondent and to the claimant? What do you think of that? What's your position on that? So procedurally, we would, approve such request, yeah, from the respondent, and then at a later stage, to consolidate those different proceedings, which basically achieve the same objective. What do you think? about this option, and what is your position on this?
Mr. President, if I'm not misunderstand your question, that your concern is our arbitration will be conducted in separate parallel arbitration, and then the tribunal decide to consolidate the separate parallel arbitration. If I
Yes.
Okay, I got your point. Thank you, Mr. President. I think as I just mentioned before, claimants submit that because there is the same dispute and the same one set of facts, there is no need to conduct the parallel proceedings for the parties. It will be inefficient and also unfair for a claimant to conduct 3 parallel proceedings. On this point will be submitted.
Counsel, I do see your point when you talk about efficiency, and that makes good sense. But what about unfair? You mentioned about being unfair to the claimant. Isn't that a purely procedural issue? How can you say that is unfair procedure? Because this is something should have been made available procedurally, yeah, to the respondent as well. Why do you think it is unfair? In what sense?
Indeed, Mr. President, it would be unfair if claimant has to go to 3 different proceedings just to get an award that states that they don't have to pay the money, and which is essentially the same measure that taken jointly by the respondents, as I just discussed before. So claimants submit that if there is the separate proceedings, then it would be unfair for claimant.
Well, the procedure, all the legal procedures, yeah, that are in place under any international treaties are supposed to be neutral. How can you say it is unfair?
Mr. President, the fact is that what we have here is the same dispute and the same fact that results in claimant's damages. And what we concern is if we have to go to 3 different parallel proceedings, then there must be more expensive for us and more time consuming for claimant to join the separate arbitration proceedings. That in order to get one award, that just to say that claimant don't need to pay the money. So claimant submit, it will be unfair.
Thank you. Please proceed.
I'm sorry to interrupt, if I may. Counsel,
yes, please.
Can I have a question? Let's go back a little bit.
Sure,
In your argument, you mentioned the respondents took joint actions or measures, which was a subject matter of your arbitration. Could you please explain what was the measure as a subject matter of your arbitration? Who took it?
Yes, Mr. Arbitrator. Please allow me to clarify. Your concern is that what the measure jointly taken by the 3 respondents, or why the measure was jointly taken by the 3 respondents.
Can you answer the first part of your question you have just phrased? What was the measure jointly taken by the respondents as per the claimant's arguments?
Okay. Maybe it's my bad internet. Sorry, members of the tribunal. Yes, the measure in this case are the acts of the commissioners of the mines that and the acts to acknowledge and adopt to the conduct of the Dutch court of the 3 countries, Prussia, Netherlands, and Belgium jointly. Then they all want to acknowledge. They all acknowledge and adopt the conduct of the Dutch court, and they all instructed the commissioners of the mines to pursue the enforcement of the concession agreement fee and the 1810 fees jointly, which results in claimants' damages.
So what's the measure, the enforcement or the judgment or the fact that the respondents sued these defendants in the court?
Well, thank you, Mr. Arbitrator. Actually, the measures are all of them. Firstly, the act of the commissioner of the mines and the act of the three countries to acknowledge and adopt to the conduct of the Dutch court of the three countries, and then the judgment.
Okay, thank you. Please proceed.
Thank you, Mr. Arbitrator. Sorry. Members of the tribunal, we ask for your attention that Article 7.1, 10.1, and Article 10.3 of PCA rules provide for a fair resolution to appoint arbitrators in multi-party arbitration. If respondents wanted to rule out the possibility of a multi-party proceedings, they shouldn't have given consent to do so in the VIT by specifically referring to the PCA rules and giving the investor the choice. Here, the investor has simply accepted the respondent's standing consent to arbitration in accordance with PCA rules. And now the respondents are saying it's unfair. May we suggest that the respondent should have thought about this before putting it into the VIT. Third, the joint arbitration is necessary to avoid inconsistency in separate parallel arbitrations and to promote efficiency, as I mentioned just now. In the words of the tribunal in Ambient versus Argentina case, the tribunal holds that the decision to institute one single proceeding is the most efficient course of action because it avoids parallel proceedings, reduces costs, eliminates the risk of inconsistent decisions. If the proceedings are conducted separately, how could the quantum of the damages be calculated? What if one tribunal concludes in favor of claimant, but another one doesn't? Does one country have to pay for the entire loss? Members of the tribunal, this concludes our submission to respondents' objection to the multi-party arbitration against all three respondents. If there's no further question, I'll move to the next issue, issue 7.
Any question from the tribunal, my co-arbitrators? Or the counsel of the claimant on issue 6 so far? Counsel, I have a very simple question, yeah? Do you think the disputes with the 3 states, are they separable? Basically means, is parallel proceeding a feasible option for the parties?
Claimant thinks there is no such possibility because the disputes are the same, and the disputes which then led to the measures taken jointly by the respondents.
Okay.
If I answer Mr. President's question, then I'm
okay. Thank you. Thank you. Yeah, please move on then to issue 7.
Okay, thank you, Mr. President. Now I'll respond to respondents' objection on composition of the tribunal. Claimants submit that there should be a 3-member tribunal with all respondents jointly appointing an arbitrator. Here, claimant makes two submissions. Firstly, we submit that there is no legal basis in the applicable rule to have three-party appointed arbitrators for the respondents. Secondly, we submit that the joint appointment does not violate equal treatment. Our first submission is that there's no legal basis in the applicable rule, which is PCA rules, to have three-party appointed arbitrators for the respondents and composing the tribunal according to Article 10.3 of the PCA rules is applicable. First of all, the default rules with respect to the number of the arbitrators and co-arbitrator appointment prescribed respectfully in the Article 7.1 and 10.1 of the PCA rules shall apply. Pursuant to Article 7.1 of the PCA rules, since there is no agreement between the parties on the number of arbitrators, the tribunal should be composed of 3 arbitrators. Article 10.1 of the PCA rules provide for a rule of co-arbitrator appointment. In the present case, the tribunal should conduct multi-party proceedings against all 3 respondents. Here, all respondents shall jointly appoint 1 arbitrator. Then respondent argued that the tribunal should allow respondent to appoint its own arbitrator separately, and they want separate arbitration proceedings, which means that they want a 5-member tribunal with parallel arbitrations and joint deliberations. We submit that the procedure proposed by respondent to appoint 5 arbitrators is infeasible because the procedure proposed does not conform with the PCA rules, with the PCA rules method for the appointment of 5-person tribunals. Respondent alleges a 5-member tribunal with 3 co-arbitrators shall be appointed by respondent respectively. However, pursuant to the Article 9.1 and 10.1 of the PCA rules, the multiple party jointly shall appoint 1 arbitrator, and the 2-party appointed arbitrators shall choose the remaining 3 arbitrators and designate one of those 3 as the presiding arbitrator of the tribunal. Third, the tribunal should be aware that the appointment of a 7-person tribunal is not allowed under the PCA rules, which may constitute my response to respondents' potential submission. If all 3 respondents have the right to appoint 1 arbitrator each, claimant must insist on its rights to appoint 3 arbitrators on its own, which is a tribunal consisting of 7 arbitrators. This would be mandatory so as to reestablish the equality of the parties' influence on the tribunal's composition. However, the PCA rules only foresee tribunal with a maximum number of 5 arbitrators. In the text of the PCA rules, there are only 6 places where the provisions regarding the number of tribunal more than 3 are mentioned, which are the introduction, Article 9.1, Article 10.1, Article 10.2, Article 12.4, and the Annex. This text only provides for one alternative, that is a 5-person composition of tribunal in the case of more than 3 arbitrators. Besides, it was very hard enough to find even 3 good arbitrators, and it would be almost impossible to find 7. Additionally, if we had a 7-member tribunal, it would be costly to appoint 7 competent arbitrators, and the hearing proceedings would be more complex. It's too expensive and time-consuming to have those kind of tribunal. Moving to our second submission, we submit that the joint appointment does not violate the equal treatment. We respectfully ask for the tribunal's attention on Article 10.3 of the PCA rules, which ensures equal treatment of both parties. The provision states that in the event of any failure to constitute the arbitral tribunal under these rules, the appointing authority shall constitute the arbitral tribunal and may revoke any appointment already made and appoint each of the arbitrators and designate one of them as the presiding arbitrator. the appointing authority may, if it deems it appropriate, reappoint previous appointees. Such a rule provides for an equal treatment of both parties because the appointing authority, who is neutral, will secure the appointment of an independent and impartial arbitrator under Article 6.3 of PCA rules.
Counsel, I have a question for you. Yeah, as I mentioned earlier, in the question that I directed to the respondent just now when he was addressing issue 6, though. So let me bring that up again. So in this case, you probably have noticed the arbitrator appointed by the appointing authority on behalf of the respondent, Mr. Ivanovsky. He apparently seems to have encountered a practical difficulty in traveling to Europe to attend the hearing. So do you think, taking into account such a situation, do you think it would qualify as the circumstance under paragraph 3 of Article 10? And do you think as a result, the request from the respondent could be accommodated under the PCA rules of Article 10?
Mr. Arbitrator, if I understand your question, you said that Mr. Ivanovsky, his difficulty to conduct the arbitration will be the situation that allows the Article 10.3 applies to our situation.
Yes.
Mr. Arbitrator, I see your concern, and I think firstly the case study, the case text of the present case, the fact is really vague, and we don't know what's the genuine difficulties that the Mr. Ivanovsky faced with, and we think that the Article 12 of PCA rules provide for the challenge of arbitrators, and Article 12 and 13 provides for the procedure of challenge of arbitrators, and these articles provide such provision that ensure the fair and equal treatment of both parties. Then, if the respondents want to raise some concern about the arbitrators, it can follow these provisions to challenge arbitrators.
Okay. Thank you. Please proceed.
Thank you, Mr. President. Actually, in conclusion, the claimant requests members of the tribunal find there should be a 3-member tribunal with all respondents jointly appointing an arbitrator. And this concludes my submissions. Thank you for your time.
Thank you, counsel. Representing the claimant, covering the issue of 6 and 7 in response to what has been presented by the respondent. Are there any other questions from the tribunal at this stage? Okay, fine. Shall we now have invite the counsel for the respondent to make their rebuttals on the submission just made by the counsel for the claimant on issue 6 and 7, please.
Thank you, Mr. Arbitrator. My co-counsel had to remind me that the respondents still have 2 minutes and 30 seconds left, so I will use those time for rebuttal. First, concerning responding to the claimant's issue 6, we would like to point one. First, the claimant is confused about the joint arbitration and the multi-party proceeding. And the joint arbitration is what the claimant brought in their submission to the arbitration. However, what the claimant had just indicated is all about multi-party arbitration. And tribunal, we know that there are several kinds of the multi-party arbitration. It has a concurrent hearing, it has a parallel arbitration, and even the joinder, it is included as the multi-party arbitration. And as we know that there is no exact definition about the joint arbitration of what the claimant has just brought, we believe that the claimant should bear the burden of proof for the joint arbitration, instead just referring to the multi-party arbitration regulations. Second, we believe that the claimant is confused about the measures of our case. The claimant had just mentioned that the cases are the judgments of the year courts and the enforcement of the year court's judgments altogether. However, as we know that the measures, they have two separations. The first is the judgment of the year court, and the second is the enforcement, which made in 1837, according to our case. However, we believe that based on two measures, and there is not the same act as referred by the claimant. And we firmly believe that the claimant is confusing about the measure of our case. And the respondent submits that the measures is only the year judgments, and the enforcement is made by the French court, which is irrelevant to our case because French is not parties of our case. And third, we believe that the claimant is mistakenly taking Article 11 of the ILC draft article about the acknowledge and adopt of the conduction, because this article is for the private entities. However, the year court, it is a state organ of the year province. It is not a private entity, which is irrelevant to our case. And concerning issue 7, there is one way we would like to point out is that the appointing rights concerning what the claimant had just brought is in violation with the respondent's fairness. And there is also an ICC case I have just referred to the tribunal, is that the Ducto versus BKMI and Siemens. And in that case, the Supreme Court of French just canceled what the ICC's joint appointment and designation about the joint arbitrators. And from this case, we indicate that respondent, their rights of appointing their own arbitrator should be respected. And that rests my rebuttal. Thanks, arbitrator.
Okay, thank you, counsel, for the respondent for your rebuttal. Is there any further question from the tribunal? We're good? Okay. Moving on, shall we now invite the counsel for the claimant to submit your rebuttal, if you have any, please.
Yes, Mr. President, thank you. To reply to respondents' first rebuttal, that indeed there is no specific definition of the multi-party arbitration or joint arbitration, but there is the case that is Ambient versus Argentina case. In this case, the tribunal decide the present dispute is not a case of consolidation of proceedings. However, but the original submission of a claim by a plurality of claimants in one dispute. This is what the same facts that analogous fact that can be concerned with our case. Our case is the same situation, that there is the same dispute and the same one set of facts. And there is another also another case, that is Guy and Rulik versus Bolivia case. This case is also a purely multi-party arbitration that is which is analogous to our case. This case is also the same dispute and the same one set of facts. So that is my response to the first rebuttal of respondents. And with regard to the respondents, the last rebuttal, we ask for tribunal's attention on the Article 10.3 of the PCA rules and the Article 6.3 of PCA rules. These provisions provide an equal treatment of both parties to appoint the arbitrators because the appointing authority is the neutral and will secure the appointment of an independent and impartial arbitrators. Indeed, there is some possibility that the authority is impartial sometimes. Then we have another set of rules to challenge the arbitrator appointed by the authority, but this kind of thing is rarely happened in real life. And because we as the client choose the PCA and give our trust to them, and we all think they will definitely provide us services as good as they can. So if the authority is even impartial, and this wrongdoing will destroy their own reputation as an arbitration institution. So that concludes my story rebuttal.
Counsel, I think you were referring to Article 17 instead of 10 of PCA rules when you talk about the equality of treatment and the treatment of equality, yeah, instead of 10. Probably, never mind.
The Article 10.3 and 6.3.
Okay, 6.3. Okay, fine. Okay. Yeah, I think it's almost time to conclude the session because we are pretty good, I think, in terms of time. We used more than like 10 minutes than we are supposed to, which is very impressive. Is there any other questions from the tribunal members? Okay, good. Thank you for all your submission, your presentation. I think you all did a good job. Before we move on to the next stage in which the tribunal are supposed to give you some feedback, I'd like to confirm with you as a procedural issue in compliance with Article 17 of PCA rules. That is, I wanna confirm with each of the teams that you have been given sufficient and reasonable opportunity to present your case, and you have been treated with equality. Do you agree, counsels for the claimant?
Yes, Mr. President, we do agree. We were very good. It was very, very good that you guys spotted my observations on the time. So thank you for that.
Thank you. So do you agree, counsels for the respondent, for the same issues?
Yes, the respondent agree. The procedure is partial and independent. It's impartial and independent.
Thank you. Okay then. Well done. Now, shall we now invite my co-arbitrators to give their comments or advice and their observations on your overall performance? It can be some very general comment. I could be directly individually to each of you. Please, Mr. Zhang or Olga, Mr. Batenko, who do you want to go first? Olga, you want to go first?
I'll go first, and
Cool.
I'm very mindful of time. I'd like to thank the presiding arbitrator and Mr. Zhang, my co-arbitrator in this hearing. It's been a very enjoyable, very active hearing. I'd also like to thank the parties, the party representatives for a very engaging debate. I'm going to give individual feedback simply because I know that the presiding arbitrator will probably give a general feedback overview of the entire hearing. And also I do believe that individual feedback is always quite helpful for the contestants, for the students participating in the moot. I'll begin with Frederick, as he was the first oralist. My first comment was that I'd like to compliment the demeanor, which I found to be very measured and very approachable. I think it's very important to set the pace for the presentation, just so that that tribunal doesn't get nervous simply because the presenter, the counsel, is nervous. I also thought that the structure was traditionally quite good because you set out the arguments you're going to make at the outset, and that also set the frame for the tribunal. I did find, though, that at the very beginning of your intervention, you found it difficult to be responsive to the tribunal's questions because you were set on your I think, script and on the order of your arguments and continuity of ownership of investment. I think you did address that later, but I think you weren't prepared to be responsive at the very outset, which happens, and it's normal. Then my other comment actually just came through now when you said, in response to the presiding arbitrator's request to confirm that both parties are happy with the conduct of the proceedings, you addressed the tribunal as you guys. And this is my personal pet peeve, in particular when people address me as a guy, simply because I'm not. And I do not believe that the gender-specific address to in a professional context is it can be a little eyebrow raising. But apart from that, I think it was a brilliant performance, and I really enjoyed your presentation and your arguments. And then I'll move on to Zhao He, I think. Yes, you spoke in response to Frederick. I think your style was quite different. It was very engaging. It was very personable, the way you immediately started responding to the arguments as they were presented. And I also thought that you found it very easy to be responsive to the tribunal's questions. And I didn't detect any problem for you to say, all right, I had that argument prepared for later, but I'm happy to take that out of order and respond to your question now, since you're interested in this question now. So I quite like that. So it was also a very sort of graceful style towards the other party and to the arbitrators, the way you responded to questions and the timekeeping situation. And I also liked your teamwork, maybe because you're in one screen. I see that you are sharing post-its and you're communicating, and at some stage, I think your colleague Go Hongyi actually responded instead of you in response to presiding arbitrator's question. I think it's very nice symbiosis. I'd like to thank you for the teamwork. A very interesting presentation. And then I'll move on to Go Hongyi. I think, and your style yet was very different. I thought you were very confident. It's a very confident delivery of message, whether you're right or wrong on the merits of your argument, but the delivery is certainly very confident. So that's rare and very good to see. Although with that, I'd like to caution you against being overly aggressive towards the other side. And one of your rebuttals, you said, we believe the claimants are confused on this or that argument. And from my personal experience as counsel in arbitration proceedings, I often have counsel on the opposing side who make the submissions to the tribunal saying that, oh, counsel is confused, counsel is under misunderstanding, or this and that rule. And I find that actually both as counsel and as an arbitrator, this is quite an annoying statement to make. You can show, if you believe that the confusion has a reason, you can show where the confusion is, but saying or this sort of personal attacks on the counsel on the other side, I find them not very helpful, but I do find your delivery very confident, and I quite like that, because you seem to want to believe you when you speak. Then I'll move on to Xinye Jiang. It's also, again, like all of you, I think the delivery and the presentation was excellent. I like the distinction that you tried to make between joinder, consolidation, multi-party proceedings, this intention to set the record straight, to explain what exactly is it we're talking about when we're trying to argue three respondents. So that I found quite useful and quite interesting. One thing I'd note on your performance is that, and that's something that I find students do quite, and I do that myself as well. When the presiding arbitrator asks a question, you oftentimes start with, as I mentioned previously, and then you repeat the argument you'd already made before. And I find that this isn't always helpful, because if the presiding arbitrator is asking you a question, that means that whatever you said previously wasn't necessarily answering the question. So repeating yourself doesn't really help, I find, in these circumstances. And also going last in the hearing is always very difficult, because the entire tribunal is now into the case. We're all asking questions, so you were in a hot seat. So it's a very difficult role to play, and I think you did really, really well. With that, thank you very much to everyone. It was a really enjoyable session, and I'll pass the floor on to my co-arbitrator, Ms. Zhang.
Thank you, Olga. So thank you for Mr. Bai and Olga. It's a very nice journey to hear the presentations from two very impressive teams. I echo with what Olga commented, so I will keep my comments as brief as I can. So I will start with the claimants team. So Frederick, you have a very clear structure of arguments. You started your arguments clearly by pointing, I have 3 issues, number 1, 2, 3, then you expand it, which is very good and very presentable, and I do like it. And also, I can get the feeling you are mastering the procedure quite well. You pointed out the running out of time of the respondent, and you squeezed them by offering a proposal. And interestingly, they accepted that. I will go back to that point when I give comments to the respondent. But that can show that you know the substantive, the merits of the case, but also you know the procedure well, which is very impressive. And please keep it. And also for Xingyue, I think you act very quickly. You are very responsive to the arguments and also responsive to the arbitrator's questions. Although there are some difficult questions from the tribunal, you try to respond, and interestingly, I can see you are adjusting your arguments to be responsive, which is very good. We can understand that when you are facing difficult questions, it may a little bit nervous, but you adjusted very well. And the only comment is, maybe I add some, during some minutes, it looks like you are reading the scripts or the computer screen. So if you can improve in that aspect, that will be very, very impressive as well. So for the respondents team, it's also very, very well done. And Mr. Zhao is very confident and also very interactive. And he presented the case by showing the charts, the timeline. It's very impressive. It's a good way to show the arguments, and by sharing the screen, by directing the tribunal and the opposing counsel's attention. It's also a way to formulate the arguments. So it's well done. It's what we have seen in other cases as well. And for Mr. Goh, you act very quickly and you are very confident. And I like your rebuttals, very clear, seeing there are 3 rebuttals, number 1, 2, 3, in a short and a succinct way, within 2.5 minutes. It's very good. The only comment is that when your opposing counsel proposes a procedural issue, do not easily say yes or no. You can consider it more, and by agreeing to that, actually you have less time than expected to answer those questions and to give rebuttals. But in overall, it's very, very impressive for 2 teams' work. Congratulations, and I do enjoy this afternoon. Thank you. So, Mr. Bai.
Thank you, both Mr. Zhang and Olga, for your very helpful and very interesting feedback to the counsels of the parties, which I think they've been looking forward to, and probably it's one of the most enjoyable parts of the whole session for the participating counsels. I do have a few comments. I'm mindful of the time that we are using, And we do have another ceremony coming up at 6. So I'll be very quick. I echo basically what has been shared by my co-arbitrators. So going individually to each of you, I think we have the first artist, Frederick Landmark. We've met, I think I was the chair in one of the previous sessions where Team 30 also participated. Frederick Landmark, I think you did a very good job. It's quite impressive. I noticed apart from the other, good performance my co-arbitrators have mentioned, I think you have one thing that impressed me as well, apart from all the other impressive things you've done, like conceding on certain points and acknowledging the concern from the tribunal is always something that would impress the tribunal, because that doesn't necessarily means that you have to change your position. And also, again, I echo what was said just now by my co-arbitrators. I think it's nice to see that you raise that issue of the timekeeping. I think it's helpful to the tribunal, and this is something that the team should be always conscious of, instead of using their time, regardless of how much they spend, and kind of indifferent, to the time they are taking. And it's always a concern, because the efficiency of the hearing is always an issue that everybody should be aware of. Thank you for, again, raising that question. And I think you've been very clear. And again, as my co-arbitrator just said, I think your structure is very clear in your presentation. And some of your response, I think, to the questions from the tribunal is very powerful. I think I'm quite impressed. And also, you're able kind of to organize your thoughts, referring to the materials, the case law, etc. That's quite impressive as well. And moving on to the second artist from the respondent, Zhao He, I think, So I think it's quite nice to see throughout your presentation that you've been able to keep a smile on your face. That's something always good to see. Being on the tribunal, you kind of get bored sometimes, I have to say, because the session lasts like more than 2 hours. It's always nice to see something nice on your face, instead of being, because litigation, arbitration are quite confrontational sometimes, and adversarial, of course. So it's always nice to have someone smiling, kind of lighten up the atmosphere a little bit. And there's one procedure that I have to mention to you, Zhao He. That is, you did something very nice. That is, you provide a screen sharing to the tribunal. Basically, I think you did a very good job summarizing some of the major events, and then putting in order the chronicle of different events, etc. But I think you forgot one thing, if I'm not wrong. That is, according to the rules, you should obtain the approval of the tribunal before you can do that. Although it's pretty easy and straightforward, I don't see any reason that the tribunal would object to that. But you should have done you should have consulted with the tribunal, obtaining the approval first before you can do that. And also, the tables, the charts that you provided basically demonstrate that you're well prepared, which is very good. And it's very apparent to the tribunal members that you know your materials well, and you can recount all the major time, the date, the events, etc. That is very helpful to give the impression of the tribunal that you've done quite some research, and you've spent a lot of time, going into the preparation for your presentation. But I think you should be also aware that try your best to avoid being monotonous sometimes, because you kind of keep the same tune, same voice. Sometimes you can raise your voice a little bit and try to have some variations. Otherwise, because the presentation is pretty long, because this is a final, is kind of different from the general round. But overall, I think you did quite a good job. You've been very impressive in many respects. Of course, you did encounter a problem, that is you used too much time. You are a bit slow, but I know you are trying to be clear and trying to make your point straight to the tribunal. But you should also be mindful of the time that you're given. That's why the opposing party, the respondent, raised an objection in that respect, and reminding that you probably have run over time a bit too much. Now let's move on to Guo Hongyi, the third oralist who presented his case. Again, I think you have been quite impressive in the way that you carry yourself. You demonstrated to the tribunal that you're quite confident. You know what you're talking about. I mean, you never displayed any nervousness, etc. I think that is something, being a counsel, that is something essential and very important as well. I think you did very well in answering at least one or two questions from the tribunal, and also in your rebuttal. I think you did quite well on certain issues. I forgot specifically which one, but I think you did very well. And also, I think you did a good job in the sense that you were able to acknowledge and concede on certain issues when challenged by the tribunal. I think you also did very well on the issue of a burden of proof in your reply to the question from the tribunal on the presence of prejudice issue. I think that's quite powerful, instantly giving a sufficient and good answer to the question. Now, the fourth oralist from the claimant, Zhang Xinjue. Well, as I said, we've met in a previous session in the general round. I think Zhang Xinjue also did quite an impressive job. You have been able to keep a very pleasant demeanor throughout the session, and showing that you are confident, and you've done quite a substantial amount of research and preparation before coming to the moot arbitration. I think one thing I forgot to say about Guo Hongyi is I echo basically what Olga just now said about your accusation about the claimant being confused. That is not the best way to do this, I'm afraid, because you can always claim that your opponent, your opposing counsel, are probably confused in certain issues with other issues. You can say that because that can be a factual issue. But when you say someone is confused, that is really something you don't see a whole lot in the real commercial arbitration or litigations. That sounds a bit more personal. Coming back to Zhang Xinjue, I think I'm not quite sure. I might be wrong, but when you put forward your position on the issue of being unfair, because I think the tribunal asked you a question why it is unfair. I'm not sure of what is the best answer, but I think what you said afterwards, regarding cost, efficiency, and consistency of the proceeding, I think those are all relevant points and very powerful. But I'm not so sure whether unfair is an effective and a good answer to that question. And also, I think you did very well. I think you adopted a very good tactic in answering one of the questions. I forgot which one, but I think the question about whether those disputes are separable. I think you refer the tribunal to the issue of impartiality and independence. I think that is a good tactic. Basically, dodging the question while providing a appropriate and decent answer to that. Yeah, I think that's more or less what I want to say. But overall, I think you all did a very good job. Thank you for being part of this session, which has been a really impressive and enjoyable one. I wish you all good luck. And if there's no other further comments from the tribunal, I think it's time for the secretary to invite you to exit and for the tribunal to have a deliberation.
Thank you. Yes.
Okay,
yes.
the floor
yes.
to you, Fanghan.
Sure. Thank you. Thank you, the teams, for delivering a great competition. And thank you, the arbitrators, for giving such comprehensive and insightful comments to the teams. Before we conclude this final, may I invite all the teams and the arbitrators to turn on your camera so we can take a group photo.
Great.
Okay, sure. Ready? 1, 2, 3, cheese. Okay. Okay, thank you. So thank you, the audience, for attending today's final of the second CTAC Cup for Investment Arbitration Moot Court. The arbitral tribunal will now proceed with internal discussion and decide the champion and the best oralist of for the final, which will be confidential at this stage. And the audience, please stay tuned for the webinar and the award ceremony tonight, starting at 6:30. You may register for the webinar and the award ceremony through the QR code displayed on your screen now. Thank you again, and see you tonight.
Before we leave, I just wanted to say thank you for all the feedback, arbitrators. We really appreciate it. Thank you again.
Thank you.
Thank you very much.
Thank you, arbitrator.
Thank you.
Thank you. Bye-bye.
Thank you. Bye-bye.
Bye-bye.